Welcome back. Former White House COVID advisor Dr. Anthony Fauci appeared before a Republican-led Senate committee today, invoking the Fifth Amendment as lawmakers question him about his handling of the pandemic and the origins of COVID-19. David Schultz is a political science professor at Hamline University, and he joins us now. David, thanks for coming on the show.
My pleasure. Thank you, Courtney.
He invoked the Fifth Amendment 111 times. That's a lot of times saying the same exact line. What was going on?
Well, he decided at this point that he did not want to testify or say anything, feeling that, again, his words or his attorney's words, feeling that the investigation was illegitimate and they were going to try to trap him into something so that they could eventually bring him up on perjury. So instead of testifying, he showed up, which he's required to do, but opted not to say anything.
How common is that? I mean, clearly it's legal. How common is it that you see somebody called before a Senate committee and they decide to invoke the Fifth?
Well, it depends on how you define common here. Is that if we go back over, let's say, the last 50 years or so, we've actually had quite a few people who have invoked the Fifth Amendment when called to testify before Congress. For example, among some of the most notable figures, let's go back to the 1980s. Lieutenant Colonel Oliver North, when he was called upon to testify about what was called Iran-Contra, he invoked the Fifth Amendment, as did John Poindexter, one of Ronald Reagan's national security advisors. During the 1990s, Susan McDougal, who was a friend of the Clinton administration, invoked the Fifth. And then we could walk through each decade where we've had a variety of people, including, for example, most recently, after the January 6th events on the U.S. Capitol, both John Eastman, an advisor to Donald Trump, as well as Jeffrey Clark, who was I think an assistant attorney general for Trump, also invoked the Fifth. And so it's not uncommon to do it. If we were to go further back in time, during the 1950s, during the McCarthy hearings, invocation of the Fifth Amendment regularly occurred by people asked to testify before either the House or Senate Un-American Activities Committees.
So at the end of the hearing, Senator Rand Paul said that they'll vote next week on whether to hold the now retired doctor in contempt. From your legal perspective, would that be possible? Could he be in contempt? I mean, he's being accused of, he was trying to avoid being accused of lying under oath by invoking the Fifth, but is that possible?
Well, it's possible that they try to indict him. Would he be convicted? The answer is no. A couple things to understand here is that there are limits on how far Congress can go in terms of its investigatory power. However, it's still broad. If you refuse to show up to a subpoena required to show up to Congress, then of course you can be held in contempt of Congress, and that could be criminally prosecuted. But if you show up and invoke your Fifth Amendment right, no, you are not obstructing justice. You are not in contempt. You cannot be held in contempt of Congress for invoking your constitutional right on the Fifth Amendment. And he's basically invoking his rights. One of the lines that I like is back in the 1980s when Oliver North was testifying before Congress and he was invoking the Fifth Amendment. And at some point, people criticize him and say, you shouldn't invoke the Fifth Amendment. You should testify. Oliver North had what I still think is a wonderful line where he said, people died face first in the mud defending the Fifth Amendment and the Bill of Rights. And I think that's basically true. We have as one of our most fundamental rights, the right not to incriminate ourselves. And we can do that without fear that we are going to be charged with a crime for invoking our rights.
What would you say to the people who say, well, by him continually taking the Fifth, that it made him look guilty, whether he is lying or not, it made him look guilty by not just simply answering the questions?
Well, a couple of different answers here. One, if it were in a court of law, let's say we were actually in a court of law and somebody's accused of a crime and they decide not to testify, the prosecution may not tell the jury or may not refer to the jury and say, hey, look at this guy didn't testify or this person didn't testify. He obviously must be guilty. You can't do that. That's punishing somebody, again, for the invocation of their rights. However, in a situation like this, where he says, I'm not going to testify, I'm going to invoke my rights, maybe the optics do look bad, but at the end of the day, he has that right to be able to do that in the same way that Oliver North, in the same way that John Poindexter, in the same way that anybody else who's called to testify before Congress has that right to be able to do that. Whatever inferences people want to draw from that, that's a different story entirely.
Fauci's attorney tried to stand up and explain why he was invoking the fifth to every question that was asked, and Senator Rand Paul kicked him out of the room. Can you just talk about, why was he allowed in the room, and then was Rand Paul allowed to kick him out of the room?
Congress has pretty broad leeway in terms of who they allow in or who they don't allow in to their chambers. Can he basically say that his attorney can't accompany him? Yes, they probably can do that. But if the whole purpose of that is to coerce or force Anthony Fauci to give up his Fifth Amendment rights, then that's a real major problem at that point. And so if, for example, they were now to try to indict Fauci for, let's say, contempt of Congress for refusing to answer. Again, as I pointed out before, you can't indict somebody or you can't convict somebody for the invocation of their Fifth Amendment rights. But two, if they're now trying to coerce him and say that you can't seek out legal counsel in terms of testimony, that raises other legal issues too.
Is that usually allowed to have your attorney with you and have them speak on your behalf, or does the attorney have to be a registered speaker ahead of time?
It's going to depend on the rules that the committee sets up. It's generally they want the person testifying themselves, but there could be some scenarios where they allow the attorney to speak for the person that they're questioning. But generally, the answer is going to be if they bring Jane or John Doe before a committee, they want Jane or John Doe to speak and not the attorney to speak.
Fauci called this hearing, he pointed out Senator Rand Paul, he claims, has an unhinged obsession with him. Meanwhile, Paul responded at the end of the hearing saying that his questions were legitimate, often scientific. Is this an obsession, or were these legitimate questions that were legally allowed to be asked?
It all depends on your political perspective. That's interesting here. Does Congress have broad leeway to gather information as part of its investigatory power, its oversight power? No question about that. However, the courts have also said there are outer limits to how far beyond Congress can go. Take us back to Trump's first term, where I can't remember if it was the House or the Senate now, wanted Trump's income tax records. The case went up to the U.S. Supreme Court, and the U.S. Supreme Court said that if the purpose of Congress is what I'm going to call, in my words now, a fishing expedition, then they're not entitled to them, and you can't do that. If the purpose is just to harass, that's illegitimate. But if you can show there's a legitimate purpose in terms of your questioning, then you're allowed to ask those questions. But again, a witness is allowed to refuse to testify. Now, and this is what happened with Oliver North, if at the end of the day you really want information, if you really wanted to know more about, let's say, the origin of the pandemic, they could do what they did with Oliver North and grant him immunity from prosecution. And so if it's truly about gathering information, granting immunity from prosecution is always the option to use.
So speaking of granting immunity, former President Joe Biden did give Fauci a pardon early last year. So even if lawmakers vote to find him in contempt, does that pardon protect him now, or does it only protect him from issues in the past?
That's a really good question here. I'd have to go back and look at what exactly the pardon said. I mean, if the pardon basically said for any crimes that may have been committed or possibly committed in the past, then it wouldn't protect him going forward. But it all depends on how broad. Presidents have incredibly broad pardoning power. I mean, theoretically, a president could come into office on day one and issue what we call a prospective pardon and say, I'm going to pardon my staff from any crimes they may commit in the next 4 years. We also know that after Richard Nixon resigned, Gerald Ford pardoned him, even though Nixon had never been indicted for a crime. And the court said the president's allowed to do that. So again, presidents do have broad pardoning power, but I'd have to go back and look at exactly what that pardon said in terms of, was it only retrospective, perspective, how broad it is. I guess I can't answer that question right now.
So what happens next? I mean, if these lawmakers move forward with trying to find him in contempt, what will happen next?
Well, if they find him in contempt of court, they would then have to get the Justice Department to indict him. At that point, there'd be an indictment. He would go to court, and I would presume at that point his attorney would move to have the indictment dismissed, arguing that his invocation of the Fifth Amendment is not obstruction of justice or not contempt of Congress, not contempt of court, is not contempt of Congress, and therefore the case ought to be dismissed.
So interesting. It was interesting to watch throughout the afternoon. So appreciate you joining the show. David Schultz, political science professor at Hamline University. Thanks for coming on the show.
My pleasure, Courtney. Thank you for having me.
All right, we're going to take a quick break. We'll be back after this.